Happy Constitution Day. Thanks everyone for having me. My portion of today's presentation examines the recent developments in marriage equality through Obergefell versus Hodges. First, let's do a recap. The interesting thing about gay rights in the last 20 to 30 years is how every moment of progress builds upon the previous one. So before getting to Obergefell, I'll start where the previous Supreme Court gay rights case, U.S. v. Windsor, left off. So in 2013, the Supreme Court in Windsor overturned DOMA Section 3, which was a federal law that had only recognized state marriages between a man and a woman for purposes of federal benefits, even if the state allowed same-sex marriages, like Massachusetts. This decision came forth in a context and a climate that was already favorable to gay rights. In Windsor specifically, Justice Kennedy, who wrote the majority opinion, used concepts of animus and dignity to illustrate the discriminatory effects of DOMA. Animus, and the reasons in which DOMA was created, moral disapproval of same-sex couples, he traced this animus to a legislative intent that preferred the teleology of the body, a concept that bolstered procreation as the reason for reserving marriage for opposite-sex couples only. The politics of the body comes into play, and essentialism that favored opposite-sex relationships trumped. And dignity in the effect that DOMA had as promulgated by animus on same-sex couples, relegating them and their families to second-class status. Now, both animus and dignity were intertwined in Windsor, but they have been looming separately in Supreme Court rhetoric over gay rights for a while. For instance, we saw animus as a huge theme in the 1996 gay rights case at the Supreme Court called Romer v. Evans. There, a Colorado state referendum that would have tolerated discrimination based on sexual orientation was considered unconstitutional because, like DOMA, that state referendum was a law created out of disapproval for LGBT folks. And, for instance, with dignity, we saw dignity as a theme in the 2003 gay rights case, Elonis v. Texas. In that case, the Supreme Court held that states cannot make consensual sex acts between people of the same sex a crime. Doing so violated the dignities of those engaged in consensual same-sex sexual conduct. So what we saw in Windsor in 2013 was the beginning of how animus and dignity were being combined and intertwined together. Now, after Windsor, once the Federal Defense of Marriage Act became unconstitutional, same-sex couples started to sue states over mini-DOMAs, or mini-state bans that many states had previously passed to restrict marriage only for opposite-sex couples. It was during this time that the seed for last summer's Supreme Court case was sown. The Obergefell case originated as 6 separate lawsuits from 4 different states: Kentucky, Michigan, Ohio, and Tennessee, that are all part of the 6th Federal Circuit Court of Appeals. And all 6 suits had verdicts that were favorable to same-sex couples at the trial level. All of them favorable based on borrowing Justice Kennedy's animus and dignity themes from Windsor. Because the states lost at trial, the states then appealed to the 6th Circuit. The 6th Circuit consolidated the appeals and reversed those trial verdicts with a decision that last fall against same-sex couples. The same-sex couples in the lawsuits then appealed to the Supreme Court. The Supreme Court picked up this appeal last winter and told all litigants to limit their legal arguments within the 14th Amendment. And then the arguments took place in the spring. Finally, in June, the court held in a 5-4 vote that state bans, meaning those mini-DOMAs against same-sex marriages, were unconstitutional. This was so specifically because the majority opinion written by Justice Kennedy held that the same-sex couples could exercise the fundamental right to marriage just like opposite-sex couples, and to deny them this right was discriminatory. And he illustrated this in particular by continuing to further and sharpen his themes of animus and dignity. In fact, in Obergefell, Kennedy takes the intertwining of animus and dignity in Windsor and places it directly into the context of state marriages. The relationship between animus and dignity becomes a device to argue why the state bans on same-sex marriages are discriminatory against same-sex couples. In addressing the argument over same-sex marriage, Kennedy views what same-sex couples are asking for is the fundamental right to marriage, the same right that opposite-sex couples already have. As established by previous cases, the right to marry is a fundamental right protected by the Constitution, but it has been excluded from same-sex couples because of the state bans on same-sex marriages. And Kennedy is now trying to justify making that right available for same-sex couples. And in order to do so, he needs to show that such state bans against same-sex marriages are discriminatory. And he uses a narrative that starts with animus and ends with the concepts of dignity to show that discrimination. Animus, as he points out at the beginning of the case, is the reason for the exclusion of same-sex couples from the fundamental right to marry. And he identifies it as a historical animus towards same-sex marriages that stem from an assumption that allowing same-sex marriages would demean the traditional institution of marriage. Now, why would allowing same-sex marriages demean the institution of marriage? Well, one theory could be that Justice Kennedy is pointing out that the moral disapproval of same-sex couples, and by extension, LGBT individuals. In effect, that would be consistent with animus he identified in Romer v. Evans and later Windsor. It's a type of bias. But he's not done. Instead, he draws upon a great sense of irony by immediately pointing out that rather than keeping the institution of marriage from being demeaned, it is same-sex couples who have been demeaned by such animus. And that marriage is so important and so significant that to not allow same-sex couples the ability to exercise the fundamental right to marry in the way that opposite-sex couples have been allowed to exercise it is demeaning under the law. There are two primary ways in which he establishes this. First, Kennedy dehumanizes the then current situation of same-sex marriages for gay couples. He uses the petitioner's own struggles to show their hardship under laws that would not recognize the relationship to the fullest. And secondly, he shows legal aspects in which state bans demean same-sex couples. The bans restrict rights of personal choice and self-determinism. You can't be apart. The laws interfere with the rights of privacy and autonomy of same-sex individuals. The bans create categories and essentially makes same-sex couples second class. The bans demean families of same-sex couples. And finally, the bans keep same-sex couples from getting the benefits of married couples. What the state bans on same-sex marriage demonstrate is this. The historical animus against same-sex relationships leads not to the demeaning of the institution of marriage, but to the demeaning of same-sex couples under the law. It leads to the taking away of human dignity. Therein lies the discrimination. In the case of same-sex couples and marriage, animus leads to indignity. At the end of the day, our laws cannot be made from hate, and it also arbitrarily cannot take away the dignities of people. This is why Justice Kennedy believes that we have justification here for extending the fundamental right to marriage to same-sex couples. Now, as for the dissents, they argue that what the majority did was a creation of a new fundamental right to same-sex marriage, reserved for gay people, instead of incorporating same-sex couples into an existing fundamental right to marriage. From this premise, which is a problematic reading or misreading of the majority opinion, each of the dissenting justices, Roberts, Thomas, Scalia, and Alito, articulated their opposing views. First, Chief Justice Roberts criticized the majority for the creation of a new right to same-sex marriage, arguing substantively that such a right was not deeply rooted in our nation's history, and then criticizing procedurally Kennedy's supposed creation of a new fundamental right as an act that oversteps the boundary of reform. Justice Thomas perceived the alleged creation of a new right to same-sex marriage as anathema to due process jurisprudence, which he argues should adjudicate only violations of negative liberty. In Thomas's view, the case would only be redressable if freedom was deprived by governmental action. Since Thomas frames the issue as an attempt to create a new fundamental right, he argues there could not be any governmental action against it so far, and thus no right to be deprived. Justice Alito argues that the majority's supposed creation of a new fundamental right drives against the democratic process because the legislature and the public should dictate such creation, not a judicial counter-majoritarian act. And finally, Justice Scalia articulates similar points regarding the democratic process as a veto, but of course he does so in a very distinct voice. In closing, what's the significance of Obergefell? Normatively, I've argued that obtaining same-sex marriage is important for meeting sexual orientation discrimination rules in the law. Obergefell is not the greatest step in the Supreme Court jurisprudence over gay rights that they could have made. But nothing in gay rights has been fast. In fact, it's always been incremental. And as a result of the animus dignity connection here, what we got to in Obergefell is the furthering of personal autonomy within the context of self-determinism, i.e. being able to exist as who you are. And being able to marry whom you choose is important for gay people in being who they are. This emphasis on autonomy and self-determinism of gay people will be very important in the next phase of sexual orientation and anti-discrimination, especially in the recent weeks with Kentucky. It's going to be likely that we'll see how this escalation of the 14th Amendment protections of autonomy from Obergefell will clash with the religious liberties afforded by the First Amendment. So stay tuned. This is what Obergefell brings us. Thank you very much.
Good afternoon. Thanks for letting me speak to you guys today. I really appreciate it. I'm going to be speaking about Michigan v. EPA. As many of you know, EPA is the Environmental Protection Agency. And as part of Congress's duties, they have the ability under the Constitution, probably in their implied powers, to delegate their power. And the reason that they have this ability is if you think about, let's say, a senator from Massachusetts who might know about fisheries, might know about tourism, might know about coastal zone management. A senator from South Dakota might know about FDA regulations, energy policy, or farm policy. And a senator from Texas might know about guns and cattle, all sorts of things. But you wouldn't expect a senator from every state to know about aeronautics. You wouldn't expect them to know about nuclear fusion. So what they do is they delegate this power. So in this instance, the EPA is the body which they delegate it to. They also have what we call enabling acts to give more power to these delegated bodies. So enabling acts like we are dealing with here in Michigan, the EPA, is the Clean Air Act. And under the Clean Air Act, Section 112, the EPA decided to regulate hazardous pollutants. These are things like mercury in particular. And while you might think that regulating hazardous pollutants from a facility can't really have an effect on you, they estimate that about 13,000 deaths a year are caused directly from these pollutants of mercury from coal burning and oil burning factories. More specifically, I thought was pretty astonishing is that over 130,000 people get asthma every year from the mercury which is emitted in these plants. So 130,000 people a year, it's a big number. So there's some debate as to how much these regulations would have cost them. The EPA says it would have cost about $10 million a year in regulations. And it would have had benefits of between $37 billion to $90 billion. The opposite side, the business lobby, says that yes, it would cost $10 billion a year. However, it will only make about $6 million in benefits each year. So listen to those numbers here. We have $6 million from the business lobby, $90 billion from the EPA in benefits. This is just such a wide range. The only thing I can attribute it to is lawyers are notoriously bad at doing numbers. But as you go forward, the question is, why did the EPA get struck down? They were struck down because when they initially were determining to regulate, they did not calculate costs. So I'm going to say that again. The reason it was struck down in court is because when the EPA went to initially determine whether or not to regulate, they didn't calculate costs. They calculated costs throughout the entire rest of the process, but not initially. The reason being, they looked at Section 112 of the Clean Air Act, and they said, Section 112 says that we have to consider health of people and the environment first, and then later on we can go to cost. This is called the Chevron Doctrine under the law, where if Congress has something that's ambiguous, the agency is allowed to determine what they think the meaning is. Here, the issue is, Scalia, writing for the opinion, said that they did not reasonably interpret the statute. So the court gave up power under the Chevron Doctrine for agencies to interpret, and Scalia is saying, yes, they do have the ability to interpret, but it has to be reasonable. And any reasonable interpretation would take into consideration cost. Here, Scalia says this is akin to purchasing a Ferrari on a whim, driving it for 2 years, enjoying it, then 2 years later you decide you want to upgrade the stereo system. You upgrade the stereo system, and when you go to upgrade it, you sit down and think, can I really afford to buy a Ferrari? So that's how Scalia. And when you look at it that way, he's got a valid point. But there's two main takeaways from this case. One, it could have some administrative law effects. In fact, in the concurrence, Thomas spoke pretty adamantly against allowing the Chevron Doctrine. So some say, and this is rather lofty predictions, that this could be the first chip in the armor to abolish the Chevron Doctrine and its progeny for years to come. I don't think that's what's really happening here, but some say that it could have a big effect on that law. Second takeaway is for environmental enthusiasts like myself, this is not actually really a hard knot to the EPA, because when you look at the numbers, this regulation was 3 years out. So at this point, 80% of coal and oil burning factories are already in compliance. So it's not necessarily a lose. Furthermore, it's going to be remanded down to the DC Circuit, where many think that instead of holding it under 112 of the Clean Air Act, they'll just uphold it under Section 111. In closing, many people are saying that the Obama administration is going to be really adversely affected by this because they're about to come out with a lot of clean carbon legislation to reduce factories. However, a lot of the authors and writers are making these lofty titles just because they want people to read their stuff. Rather, a lot would posit that this is going to give the Obama administration a level of which to compare doing it the right way. So moving forward in carbon legislation, they'll know to consider cost at the very forefront of the issues. Thank you very much.
The case I'm going to discuss is Elonis versus the United States, and I'm going to take the perspective of Mrs. Elonis on what the results and consequences of this case would have been for her and for other women who are abused. The facts of this case are that Mr. Elonis, this went up to through the court system because of threats that were made or the alleged threats that were made on Facebook. So the background to this is Mrs. Elonis left the marriage and the residence with the party's 2 young girls and filed for divorce. Now this is a very dangerous time for anyone who's been abused in an intimate relationship. 75% of the women who are killed by an intimate partner or former intimate partner are killed at the time of leaving, preparing for leaving, or after leaving. So it's no surprise that if this was an abusive relationship, that this was also the time when Mr. Elonis became more aggressive in public and what he had to say. And the public piece of it actually increased her danger statistically. So this is the sort of thing that Mr. Elonis started posting. He claimed that at the time of the separation, he started listening to increasingly violent music, and also somewhat belatedly claimed to be a rapper, but I think that might have been defense planning retroactively. There's no indication that prior to this he had any history with rap. And by the way, there have been aggressive, and often inappropriate criminal charges brought against rappers. But Mr. Elonis had no prior history of this. So in this post, he says, "I'm not going to rest until your body is a mess, soaked in blood and dying from all the little cuts." This is how Mr. Elonis started his Facebook postings. Next one is, "There's one way to love you. There's one way to love you, but 1,000 ways to kill you." Now, part of the defense was that there's nothing that indicates who these threats were directed at. But what we do know, one of the facts from the courts was that Mr. Elonis called his wife's sister to make sure the wife was seeing these posts. Then the FBI visits Mr. Elonis because Mr. Elonis starts behaving threateningly at work and creating posts that appear to threaten coworkers. Someone from his place of employment calls the FBI and they begin an investigation. Mr. Elonis also posted that there were enough elementary schools in a 10-mile radius to initiate the most heinous school shooting ever imagined. So the FBI does their investigation, and then Mr. Elonis predictably starts posting what could be interpreted as threats against the FBI and against the local sheriffs and police and state police. So I'm willing to guess that no federal action would have been brought for threats against Mr. Elonis if it had only been posted against Mrs. Elonis, but once he started making threats after the FBI left and threats against police and sheriffs, then action is taken. The last one I have here, although he posted many, is fold up your PFA, put a bullet in your pocket. Put it in your pocket, is it thick enough to stop a bullet? And now he's using his rapper name, Tone Dougie. So these are just a portion of what he posted. He also posted what appeared to be an invitation for someone to attack his wife at home, and had a reference to there's a cornfield out back. It would be easy to launch a mortar into the sunroom. There's a road right behind the cornfield for easy escape. And he posted a map of her house, a diagram of the rooms in her house. So Mrs. Elonis obtains a civil protection order. And for her, this is probably where the legal action would have stopped, but for the other threats. So what goes up to the U.S. Supreme Court then, after Mr. Elonis is convicted, is whether or not these were true threats in the legal sense that were appropriate for conviction under a criminal statute. Now, Mrs. Elonis has proceeded under a civil statute to get her protection order, but this is a criminal statute. Part of this issue is who gets to decide whether or not a criminal offense has occurred. And by the way, just the posting of these threats themselves at the timing of leaving would be sufficient for a judge to enter a protection order, maybe on the threats alone, even if they were still living together. But you combine that with her leaving, and it really increases the danger she's in for a violent episode, even if there had been no violent episode before. So it's unrelated in many regards when the violence starts. But if it starts at separation, it's certainly dangerous. So the government argued that you only need two elements to prove that the person made a true threat. And one is that the person making the statements understood the context and content of the words, and that a reasonable person understood those words as a threat. This is the part that gets the government into trouble, is using the reasonable person standard. This is a standard that's usually used in civil cases. So if you're involved in a car accident, there's a lawsuit, or other type of non-criminal lawsuit, very often it's a reasonable person standard. And the court decided that, first of all, a third party, i.e. the government or this mythical reasonable person, isn't appropriate for basing a decision about criminal liability. On the criminal side, we have someone's liberty at stake. Civil standards of proof are not appropriate in the criminal side of the law. And there was an 8-to-1 decision. Some of those were concurrent decisions in favor of Mr. Elonis. I agree with the majority. I believe this was an inappropriate standard. But I want to discuss for a minute the consequences of this. And by the way, the court left the problem unresolved because they said that the reasonable person standard was inappropriate to determine a true threat, but they didn't tell us what that standard ought to be. So surely a similar case will make its way back to the U.S. Supreme Court for a determination of the appropriate standard. And several justices and many of the amici argued that this ought to be a recklessness standard. Mr. Elonis wasn't as concerned about what the standard ought to be because his position was simply that his conviction should be vacated, which it was. So we'll probably see the similar facts again with the court. I'm not quite done. What I want to point out here are two things. And this is part of an amicus brief that I joined. One is that when companion criminal cases happen in civil domestic violence cases, it's not good news for the party that's been abused. A couple of things. One is that the courts start using the criminal results as evidence of whether or not the person looking for the protection order is credible. So if there's a companion criminal case and a party is found not guilty, and then let's say with these threats, Mrs. Elonis then goes to court looking for a protection order, if she didn't already have one in place, a judge might confuse the standards, and this happens very often. A judge will say, well, he was found not guilty on the criminal side, so I'm not going to enter the civil protection order because clearly you were found not credible in your testimony on the criminal side. The fact is that what happens on the criminal side is such a higher standard that it should not impact at all what happens with the civil protection order, but it does. The other thing that will happen here is that judges will start misconstruing what the consequences of Elonis are. This doesn't mean that threats weren't made. Clearly, I think on the civil side, we would certainly interpret some of these threats, some of these statements as threats to Mrs. Elonis, particularly if the diagram of her house is put on Facebook. But courts will start getting confused there also on what this means for civil cases, and it frankly should mean nothing for civil cases. We have a comparable case working its way through the Massachusetts Supreme Court. But they will start saying that, well, we can't take threats on Facebook to enter a civil protection order. You can do that. It's just on the criminal side you're going to need a much higher burden of proof. So this is going to be problematic. Massachusetts has already ruled they're not going to require someone to take down social media postings, but they can use them to enter a civil protection order. So we'll wait to see what happens, but I expect this was a compounded problem already on mixing up the standards in civil court, and I don't expect the problem to become any easier as a result of Elonis. Thank you.
I thought I'd talk to you about a case called Johnson versus United States, which is a criminal case. And it involved the Armed Career Criminal Act 1984. might better know as 3 strikes and you're out there. And this gives prosecutors the option, when someone is convicted of a serious felony, he has 3 or more prior convictions for serious crimes, he can ask for enhanced sentencing, meaning a longer sentence. It's been around since 1984. The problem is the language is kind of vague about what might constitute a violent crime that would qualify as one of the 3 strikes. And in June, the court said basically that it was so vague, this language, it was unconstitutional. He struck the language out. The defendant here was Mr. Johnson, who was a white supremacist and someone that played a large arsenal of firearms and explosives. And he planned to blow up the Mexican consulate and aggressive bookstores and liberals. He made a mistake talking to FBI agents who were undercover about this, and they charged him with legal possession of firearms. He pled guilty to that charge. If he had not had 3 prior criminal convictions, he would have got up to 10 years in jail for that. But he had 3 prior convictions. They asked for 15 years, and they got it. He appealed that. And his basis of appeal was that one of his 3 prior crimes should have counted. He had been convicted of possessing a sawed-off shotgun in Minnesota. He said that was not a violent crime, he said. The problem is the language of the statute is specific to a certain point. It says that crimes included are burglary, arson, or extortion, or possession of explosives. Then it gets very general. It says, or any crime to otherwise involve conduct that presents a serious potential risk of physical injury to another. That's kind of a catch-all phrase. It's called the reserve clause by the court. And it's problematic. It's pretty broad. The lower courts have differed over the years how to interpret that. What crimes would count under that reserve clause? And the Supreme Court itself had 4 prior cases in 8 years on that same question. Each time had a different answer what might be a serious crime under that reserve clause. The test varied. The only constant was it said that a judge making a decision had to think about these crimes in a categorical sense. You couldn't look at the particular crime involved here. That would vary from individual to individual. It had to be that crime in general would involve a serious physical injury. The problem is the standards is very vague. We talk about burglary, arson, those can seem to be violent, but extortion probably would not always be a violent crime. It might turn out that way, but it wouldn't necessarily be that way at the start. So it's a hard decision for a judge to make, to think in the abstract whether a particular crime does involve violence or risk of serious injury. After these 4 prior attempts to try to figure it out, here the court said, we give up. This is too vague, unconstitutional. It reversed itself. That's unusual. One Justice Alito dissented, said it shouldn't be that easily. It is workable, and the court basically just gave up lack of patience and didn't want to deal anymore. There's a large effect from this because the same kind of language is used in other federal statutes. The court did address that and said, well, in those cases, the difference is that it's not a categorical approach. The judges can use the specific facts of that case. Was the defendant going to be using violence or physical injury as a result? One reason they didn't do that here, they said because, well, sometimes if these prior convictions are based upon pleading guilty, you know the actual record. You wouldn't know whether the facts were to make that decision. But that issue is unresolved. The other problem here is, does this apply retroactively? This has been 1984 that started. Many people have been convicted under this statute and gotten longer sentences. They're probably going to be appealing that now because it's unconstitutional. The court didn't address that at all. I tried to do a search to see whether or not these appeals come forward from earlier cases. They have been. People are saying that the prior sentences are unconstitutional because they came under this vague statute. It'll come back, no doubt, to the Supreme Court again, probably in the near future. And once again, there'll probably be a crowded docket with these cases, which we tried to avoid in the first place. So, at the time being, the statute is still in effect, but the reserve clause itself has not been interpreted to give judgments guidance how to apply that. So, it's going to have a ripple effect. It'll be in the news again, no doubt. As for now, it's very much uncertain. Thank you.
The formidable task of talking about a really ugly and disturbing case and trying to raise up the constitutional concerns that when the facts easily could cloud anybody's rational judgment and thinking about this particular kind of case. I'm going to be talking about the case of Ohio versus Clark, which is a criminal case, and it was decided by the court last term. And it involves a man named Darius Clark and his girlfriend's two very young children, LP, who's just 3.5 years old, and LP's sister, who's almost 2 years old. And so the facts are that basically Clark and his girlfriend had an arrangement that whenever she went out of town, the details of that I'll spare you, she would leave her two children with Clark, and he would be responsible for them. And during one of her absences, Clark, as he had done before, took LP, the 3.5-year-old, to preschool. And on this particular day in 2010, the teacher noticed blood in LP's eye. And so the teacher asked LP, what happened? And LP said that he had fallen. And so the teacher looked more closely. She could see marks on the boy that she thought looked like whip marks. And so at that point, she took LP to the head teacher of the preschool. And the teacher noticed the same marks and asked LP, quote, "What happened? And who did this to you?" And reluctantly, LP, over the course of perhaps a few minutes or so, said, Dee Dee. As I mentioned to you, Clark's first name is Darius. The teacher then took LP to her supervisor, who then lifted up LP's shirt, where she observed red marks all over his chest and the rest of his body. The school then called the state-run hotline for reporting abuse, as mandated under state law. And LP and his sister were forthwith removed from Clark's home. So Clark is charged with several counts of felony assault, domestic violence, and child endangerment. And at his trial, prior to the trial beginning, the judge determined that LP, who was 3.5 years old, was too young to testify. Okay, that he wasn't competent to testify. And this meant that the prosecution needed to be able to use LP's statements to the preschool teachers in order to be able to link that the injuries to LP were caused by Darius Clark. So they needed to use those statements. And those statements, as I explained, were made obviously out of court at the preschool to those particular teachers. Now, it's the use of these out-of-court statements that's the subject matter what took this case to the United States Supreme Court. And it is one of many cases that deals with out-of-court statements and its impact on the Sixth Amendment right to confront one's accusers. Now, the judge who presided over Clark's trial allowed the statements to be used against Clark. And despite Clark not having the opportunity to be able to cross-examine the maker of those statements, specifically LP, right? So the statements came in against Clark without an opportunity for Clark to cross-examine LP about the statements. That issue of confronting the person accusing you of crime implicates the Sixth Amendment right under the U.S. Constitution to confront one's accusers. Now, Clark was convicted, and he was sentenced to 28 years in prison. But on appeal, so at the Ohio Court of Appeals, the court determined that the trial court should not have let in these statements of LPs through the preschool teachers because Clark didn't have the opportunity to test the veracity of those statements because he couldn't confront and ask questions of the person who made them. Not only did the appellate court agree with Clark, but so did the Ohio Supreme Court. affirming the intermediate appellate court. So then the case goes to the United States Supreme Court. Now, let me just say a word about the use of out-of-court statements in criminal trials generally. And that is to say that in the last 10 years or so, the Supreme Court has done just about probably a 180 on how it determines the admissibility of out-of-court statements that are used against criminal defendants. The change first came about in a case called Crawford versus Washington, which was a case where a wife of a defendant was prevented from testifying at her husband's criminal trial due to a marital privilege that basically disqualified her from being able to take the stand and give testimony against what was soon to be her ex-husband. So the government basically, because she couldn't testify, tried to use her statements that she made to the police in an interrogation because she was suspected as well. The government attempted to use these statements to implicate the husband without not actually having her come to court and testify. So in this case, Crawford versus Washington, which was about 11 years ago, the Supreme Court said that the use of her statements against her husband, against Mr. Crawford, was a violation of the Sixth Amendment because, again, he didn't have an opportunity to cross-examine her, the maker of those statements. All that we had was the police officer who was testifying about what she told him. The most fundamental tenet of the Sixth Amendment is the right to confront witnesses, to be face-to-face with witnesses and before the jury, ask questions of those witnesses and let the jury see with their own eyes and listen with their own ears as to the responses and the body language and the demeanor of the person who's answering those questions. That is a central tenet of the Sixth Amendment. Several cases followed Crawford formulating a test for how to assess the admissibility of out-of-court statements when a witness does not testify in a case. And I'm going to skip over those cases for purposes of time, unless you're in my evidence class, which I see so many of you are. We'll be getting into this in a lot of detail. But suffice it to say that the last 10 years has produced case after case, really, where the Supreme Court has tried to figure out when is it permissible and when is it not to use statements of witnesses for whatever reason who do not testify in trial in a criminal case. So back to Ohio versus Clark. So interestingly, the Supreme Court, this was a unanimous decision, 9-0, held that LP's statements to his preschool teachers were admissible against Clark. There were 6 justices who ruled that way for one reason, 2 justices who ruled that way for another reason, and 1 justice who ruled that way for an entirely different reason, which of course we call majority opinion and the concurrences. The reasoning around why the statements were allowed is a bit complicated. It requires more knowledge of prior case law than I think this audience may have, although perhaps not. There are a lot more law folks in this room than I anticipated. But I want to say about this case a couple of points. And one thing, probably the most important point that I want to leave you with from this case is what 6 of the justices said about child witnesses. Because I think that here we have a statement where the court kind of goes out on a limb and says some things about child witnesses that I think can foreshadow in these types of cases the fact that we can anticipate that statements of young witnesses, maybe as young as 3.5, maybe even a little bit older, would be admissible in criminal cases without the right to confront. The court wrote in the majority opinion, which was written by Justice Alito, that, quote, statements by very young children will rarely, if ever, implicate the confrontation clause. And interestingly enough, Alito says that that is likely because it would never be presumed that a 3-year-old's intent would be that his statements made at the time would substitute for his trial testimony. That's likely true. I would say that that would be true for many people of all ages in many types of situations. But it's a very bold statement, and it rings really loud. If you're a criminal defense attorney or a prosecutor, there's a suggestion here that a criminal defendant could be prosecuted for a crime with statements by his young accuser who never comes to court and testifies before a jury, where the jury never sees the witness telling his story, and the defense lawyer can't ask any questions of the young accuser to test his account of the events and his credibility. And that really marks a potentially huge shift in the law of confrontation. Thank you.
Today I'm going to be talking about Alabama Legislative Black Caucus v. Alabama, as well as Alabama Democratic Conference v. Alabama. These cases were consolidated and heard together. And both of these cases have to do with the Voting Rights Act. And as many of you probably know, the Voting Rights Act was enacted to deal with several injustices that were occurring relating to minorities in voting. So here, Alabama did their redistricting for that's required with the census. And both the petitioners here challenged the redistricting, claiming that the way that they had done it was too specific in how they had allotted the blacks in the districts in question. So here, the Voting Rights Act wants to ensure that minority districts have the ability to elect their preferred candidate, whoever that may be. And what Alabama did is they went back to the numbers they had used 10 years prior, and they used those exact numbers almost. They were off by 1%. And the Voting Rights Act does not require exactness. It requires being around 5% of what you had the year before. They don't want a huge shift in population to not be able to be accounted for, but at the same time they want to make sure that this ability to elect preferred representative is still maintained. So here they were challenging that, and the court was looking at this idea of retrogression, which is the idea that you get to a point where the population changes and finally the minorities in that district are unable to elect their preferred candidate. So here Alabama was claiming that because they had done exactly what they were supposed to, they were still allowed to elect their preferred candidate, and it shouldn't matter that they had been very specific in their numbers. And the district court agreed with that and said that on a statewide level that there hadn't been any racial gerrymandering. However, the Supreme Court, in an opinion by Justice Breyer, found that they were being too specific in how they did this, that they weren't looking at the general idea of electability of a preferred candidate, but were instead trying to maintain a very specific number based on race. And because that wasn't the most restrictive means, because there were other means of doing it that weren't as restrictive, it was violating strict scrutiny. So here, it was vacated and remanded. And one of the things that will probably happen with this case is that Alabama will fix their numbers and they will come back and say, look, we fixed the problem. We're not being too specific. We're following exactly what the Voting Rights Act says. But another thing that came out of this term is a decision from Arizona, which says that now independent organizations can actually be used to just to do districting for voting, which it will be really interesting to see kind of how that combines with concerns about racial gerrymandering or even political gerrymandering as things move forward. But here, the petitioners did succeed in their challenge to the Alabama current districts, and it's going to be very interesting, I think, next few years as people move through with the most recent census and try and get their districts together in time for the next presidential election with this.
Question for Professor Barber. What was the basis? Was the basis of the Ohio Supreme Court ruling on the confrontation clause?
Yes. So essentially, Ohio versus Clark is really a bit of a departure from the cases like Crawford and Michigan versus Bryant and Bull Cumming and these other cases that in this whole progeny of confrontation clause cases over the last 10 or 11 years that really are essentially prohibiting statements that are made out of court whose veracity can't be tested, that constitute what the court has declared to be testimonial in nature. They would be disallowed if the witness is unavailable. So basically, the court, the Ohio Appellate Court, as well as the Ohio Supreme Court, kind of in keeping with those cases, made a finding that this would violate the Sixth Amendment Confrontation Clause, and basically used Crawford and those other cases to support its opinion. So really, Ohio versus Clark is a departure from what we've been seeing. Maybe for carving out statements made by a particular group of people, or maybe suggesting that the court has kind of reached a tipping point in its inability to prosecute and kind of hamstrung here in cases where they don't have, for one reason or another, the witnesses they need, and hence they can't prove their case because they can't get those statements in. And obviously this set of facts, particularly around the age of the child, suggests that maybe there, in these particular types of instances, there should be an exception. I think that the other piece of this is that the court really has kind of changed the framework of how the test for how it considers the admissibility of these statements. One that used to be about reliability and now is about whether this meets the definition of a testimonial statement or not. I mean, those DV cases that essentially the woman's on the phone, she's on with 911, he's beating her, and she's saying, defendant X is hitting me, he's hurting me. And those cases have said, in that instance, those are not testimonial statements. They are non-testimonial, they're made in an emergency type situation, and those are admissible against a criminal defendant. But these statements were really different, I think.
Because of questioning?
Well, questioning and the context, the time and the place in which it occurred. The preschool teachers at the preschool speaking to him and asking questions, and the question there would be, is this an ongoing emergency, or is he in a safe place with an opportunity to bring in other professionals and engage in a videotape type of question? So it really stands apart from those very obvious emergency type situations, and that's what's kind of unique about it.
So before the court carved out the testimonial exception, right? So how did they ever convict someone who abused a very young child in a private setting?
Well, the test prior to Crawford was to basically was a test around reliability. This is essentially Ohio versus Roberts, California Green, those cases that when we went to law school, they were the seminal cases that centered around reliability. So, I mean, Crawford and then Melendez-Diaz, these were game-changing because basically, suddenly you couldn't use a lab certificate as proof that the drugs in the trial were cocaine. You needed to literally bring in the analyst. So what really shifted in about 2004 was that the court said in a criminal trial where the Sixth Amendment guarantees the right to confront, there are no alternatives to that. It means the right to confront, literally the right to confront. Even in those cases where they've used a child witness testifying behind a screen or a curtain or something of that nature. But there's no doubt, I mean, that domestic violence cases, child abuse cases, they pose significant obstacles for prosecutors, right, around credibility, testimony of the alleged victims, whether it's on competency or credibility. I mean, even if a child can testify who's 5 years old, there are going to be plenty of inconsistent statements and issues around how credible is this child's story. Nevertheless, being very much aware of those issues for prosecutors, the court has turned to the Sixth Amendment and said there's no substitute here. You still have to have that right to confront. Ohio versus Clark, I think, is saying something a little bit different.
If you happen to recall, do you remember the statutory language that required the cost-benefit analysis and how specific it was? And then second, whether you do or not, do you think that Scalia's analogy is really an apt analogy comparing having a Ferrari to clean hair? One is sort of a luxury, might not be considered a luxury.
Yeah. So in regard to the language, I don't know the exact language, but it wasn't, the language didn't say that they had to consider cost. It was that Scalia said that given tradition in America and agencies in the past, they always consider cost before regulating, is what he's saying. So it was because it was ambiguous that it could have went either way. And then in regards to the Ferrari, exactly what you said is the first thing that stood out to me when I read the case. I'm rather an environmental enthusiast, and I was thinking right off the bat, why are we even talking about money? The issue is not money here. Like you said, you can't put a Ferrari in a clean air in the same spot. And my view is you can't, rather you shouldn't, be considering strictly business costs when making legislation, because one day, if there's no clean air, then we're not going to worry about business costs. It's just how it comes down to, what it comes down to. So I do not agree with Scalia's rationalization. However, working in the practical structures of the world, I do see that legislatively and in adjudicating issues, we do have to consider costs when we do things. However, the EPA did consider costs throughout the entire rest of the process. So the dissent stated that it's absurd that we're saying just because at the very initial stage we didn't consider cost. And so Scalia's comment was rather colorful, like his comments usually are. So I disagree.
Colorful or words.
Yeah.
I have a question for Professor Cole. This is not my question, but I'm channeling what some critics before and after the marriage equality decision have said. So if we consider the Supreme Court by a slim margin establishing or recognizing the right to marriage, not same-sex marriage, but the right to marriage, as you pointed out, so the questioning goes. If individuals have a right to marriage, why wouldn't they also have a right to marry more than one person?
That's a very good question. And that question is often posed to criticize this opinion. But if you look at the opinion never talks about more than one person. It's very strict, very narrow. It always talks about two people. He's very careful and calculated in sticking to, this is the premise at this point. We're only going to talk about marriage between two people. We're not going to talk about polyamorous marriages. We're not going to talk about polygamous marriages, even though those things exist culturally in areas of the world and also in parts of the United States. But this opinion is directed to a marriage in which we understand it to be as two people, one and two. So that there is. So the questions about polygamous marriage is often one that is a distracted one, and I think that it will take a long time to have that discussion. If you track the history of same-sex marriage becoming illegal, you need to have a lot of cultural and contextual favoritism towards that idea. You have to warm up to that idea even before we get to it. So that's one I think reaction. I think from at least for me is to say that I don't think that's going to be a big issue. That's at least legitimately going to be on the table. The other issue, the other question I have is there are polygamous marriages throughout the world that exist, and there are systems in different cultures that actually have accepted that. One criticism I always have about Americans in the not American, so I should say that about myself. But when we talk about polygamous marriage, we're talking about the form that we see on Big Love, or on, you know, and it's in some ways very heteronormative. It's very male-centric. Why can't we have polygamous marriages where the female is the one, you know, has several husbands, or same-sex polygamous marriages? I mean, it's very interesting when that question is posed. It's a particular kind of polygamous marriage. It's a particular kind of way it's phrasing. It's coming from a particular place, and all of these sort of, if you unravel the question and you place it in the context of sort of incrementalism, and how even sort of seeing how, by analogy, how same-sex marriage became something that was within the law, you can see that the question has a lot of flaws in it. So it's very interesting to reach into that. My own family, I'm Chinese. I'm first generation immigrant, but going back to my family, I have two great-grandfathers on both sides of my family who had several different wives. And the purpose of marriage at that point was not because of love, it was because of aggregating property. So, and I don't see any, real contentious issues in my family. And I'm still here, yeah. So, the point is made is I think that's a very reactionary question, and it's also very distracting in the process.
I accept both these terms, yeah.
It was the very question that Justice Alito was asking, the lawyer for plaintiffs in this case, right? I mean, he was, and giving all kinds of various scenarios, multiple people, siblings, etc. So it was, if you listen to the oral argument, you can hear that entire exchange.
There's been some fallout on the case, within the system, and most recently the Kentucky issue with the woman refusing to issue certificates. I was wondering if anybody would like to comment on that.
My initial thoughts is that will go away. And it is going away. We haven't seen as much of her this week as we did last week. She certainly has her own feelings about this, but she is also a governmental employee, and there are restrictions on that for the Constitutionality. What would sort of govern her or not govern her? So that's my own comment. I think giving her more comment is kind of problematic. So that's what I would say.
We're seeing a lot of resistance in different formats. This was the case, however, that came up the first time in the government context. Before that, there were several civil suits against the wedding planners. I call them the wedding cake resistors. So people who refuse to provide wedding services for same-sex couples. And those seem to be pretty quickly dispatched depending on the underlying state law. But what was significant with Kentucky was it was the first case that came up. Even though there have been other state actors who refused to marry same-sex couples or issue licenses, this was the first one to get to the courts. And I think that makes it significant in terms of how it was handled.
Well, an interesting thing, though, to see that is the resistance is based on a conscious exception or in some adherence to religious liberties, and I think that's where the next progress in gay rights will actually venture into is around where we have to figure out how does gay rights sort of coexist with religious liberties, and so that will be, I think, a very interesting venture. I don't know exactly how that will pan out, but I think leveraging from Obergefell is going to be an important step in bringing that new argument, 14th Amendment personal autonomy versus First Amendment religious liberties together, and then figuring out how that's going to do it.
I think I felt pretty much what I hear from both of you, that like this will pass, and that it's a government employee, so that's different. Until I watched the early debate last night, where I heard presidential candidates say, who are they to tell us what the law is, right? So I guess I just want to say that I'm very troubled, and I'm wondering what would have happened in Bush v. Gore if Trump had decided not to sign the election ballot. I mean, I guess now, however many people watched the early debate, at least, and I don't know how much of this was in the later debate, think that it's okay to say that just because it's okay to think that the Supreme Court doesn't get to tell us what the Constitution says, whether we like it or not. I happen to like their decision in Obergefell. I don't like it in Citizens United, but it's the law, right? And so I felt more sanguine about what the future of Obergefell would be, and what would happen at the next stage, as you point out, when they're weighing religious liberty against other rights, right? Until I thought that millions of people now think that the Supreme Court doesn't tell us what the Constitution says, and if it does, it can just be changed like that by somebody who's not in the school.
Or defied.
Right, or defied, right. So.
Well, and the cases are starting, so at some point there will be a small business or, family-held corporation like Hobby Lobby that will raise the issues of do we have to provide services to same-sex couples when it's against our sincere religious beliefs. So those cases will continue to occur. Someone will wend its way through the courts and back to the Supreme Court. So it's not over in terms of decision makers. The small businesses that to date have been the ones resisting services to same-sex couples are the ones who have not been successful, but primarily those cases have not been successful on state constitutional grounds, not the U.S.
And sanguine is right. I think sanguine is right. But that is sort of also what I want. As a scholar and as somebody who studies this, and also someone who might be affected by this, in the long haul, because I want that discussion between where does my personal autonomy rights go and where does religious liberty rights go as well. How do they coincide and coexist with each other? And we don't get there unless we have a lot of loud voices on both sides. This is how the politics, the process of politics works. And so this is going to be an unstable time for a little bit, despite the ruling. It's interesting to note, if you watch, you just kind of rewound back to June, that after the opinion came out, there was this huge sort of wave of goodwill and celebration and all sorts of revelry about this opinion, where we landed, had some progress, and now we're starting to become more sober, and especially as we move into from one political climate to another, especially with elections. It's interesting to see how now we've got these reactionary sort of rhetoric coming out to play a little bit more and giving more airtime. We've seen instances like the cake bakers, or also the people who refuse service to same-sex couples. We have the Kentucky issue. I think that's going to be sticklers for a while, and that's going to provoke the debate further, and at some point we'll come back to the courts again, and we'll see how that is done. So I welcome that, actually.
And the civil cases have been brought by, typically by the couple that's been denied services. So I think the next step is for the person who doesn't want to provide services to be organizing strategically to bring a suit, following Hobby Lobby.
I mean, this is for students who are in law school. I mean, this is an example of politics at work. It's an example of how, pursue justice. That's the theme we have in our school. And how all this is tied in a very slow narrative, but one that has sort of all these different players, and each step leverages the next step. So it's maybe not as dramatic or as short-livedness in a trial, but it certainly has sort of patrimony insurance.
Well, I want to thank our panel here for
Thank you.